So welcome back everyone to the second panel of today. My name is Katharina Theil. I'm a solicitor here at LIDE in the International Department, also specializing in human rights and environmental litigation involving multinational corporations. The topic of this second panel is natural resources, extractives, referring to the extractive industry, companies working in the extractive sector, and sustainable development. I'm very pleased to introduce our excellent panel on this topic, who will provide their contributions from a range of different perspectives. And I will introduce everyone now, because there's we have some speakers joining us remotely a bit later, so I'll just go through them all in the order of their contributions now. So firstly, we have Leif Winnaar. Leif is the co-founder of Clean Trade and the chair of the board of trustees. He holds a number of professorships at Stanford University in humanities, as well as law and political science. In addition to name but a few positions, he has also been a visiting professor at Princeton and Stanford and had a number of fellowships, including at the Program on Justice and the World Economy at the Carnegie Council on Ethics and International Affairs. Secondly, we are very pleased to have Michael Lindfuhr, who's joining us remotely from Geneva on his lunch break, which is why he's not just here yet, but he should be joining us in the next few minutes. Michael is the Deputy Director of the German Institute for Human Rights, the National Human Rights Institution of Germany. He's a political scientist, and he's also a member of the complaint mechanism for 3 European development finance institutions, and a member, most importantly for the purpose of today's discussions, a member of the UN Committee on Economic, Social and Cultural Rights, where he currently holds the role of vice chair of the committee. And I'm sure he's going to tell us much more about the work that he's doing with the committee at this stage in a little bit. Our third speaker then is Kavita Modi, who's a colleague here at LIDE. She's a senior associate solicitor in the International Group Litigation Department. She has more than 15 years of litigation experience and has worked on a number of notable cases at LIDE. Currently, she's acting in claims against Shell on behalf of more than 2,000, actually more than that, right? 2012, she'll tell us more about that, individuals in Nigeria who allege that their environment has been devastated by oil pollution. And again, we'll hear more about the case a bit later. And then last but not least, we have Rosa Maria Mateus Parra. Rosa Maria is joining us remotely as well from Colombia, which we're very grateful for, because in Colombia, we're at a much earlier hour of the day than here. And therefore she'll be joining us a bit later as well, together with an interpreter, James Lupton, who will be providing interpretation for us. Rosa Maria is a Colombian lawyer at CAJAR, a collective of lawyers in Colombia focused on human rights. She coordinates CAJAR's work on defending the land and fighting against the climate crisis. From this work, she has gained extensive experience working directly with local communities across Colombia that face serious human rights violations and supporting them in protecting their fundamental rights, including rights to their land, autonomy, and ways of life. As before, we should have ample time for questions again. And the way I'd like to organize it is that we'll pause after Michael's presentation, because he's going to have to leave slightly early. So to ensure that there's time for questions to him, specifically, we'll just pause after his presentation, and all the other questions I'd ask you to keep until the end. So with that, without further ado, I will hand over to Leif.
Thanks so much, Katharina. And thanks so much to Richard and to LIDE for their wonderful hospitality, as always. Since Michael is going to be with us soon, I am going to go straight to the core of what I have to say. We're talking about sustainable development, and let's just take sustainable development as it was defined a generation ago in the Brundtland report. Development that meets the needs of the present without compromising the ability of future generations to meet their own needs. What are the biggest challenges to sustainable development today One of them is the resource curse. There's something about having resources in your country which can really be disastrous for the politics and the economics, and you can see it in these statistics. Most authoritarian regimes are in resource-rich countries, from Central Asia to the Middle East, Africa, South America. Most of the world's most corrupt countries are oil states. Most of the world's recent civil conflicts have been in oil states, from Myanmar to Syria, Azerbaijan, Libya, and Nigeria. Most refugees have been fleeing from resource-rich states, oil states. Most of the countries with most hunger are oil states, and soon most extreme poverty will be in oil states. The resource curse is anti-sustainability, and it's anti-development. It's a complex global phenomenon. But what's critical about driving the curse is that all countries make it legal to buy natural resources from authoritarians and armed groups. This is what empowers those unaccountable actors to start conflicts at home and abroad. It empowers them to oppress and neglect the people of their country, to flout global norms, and it throws the international agenda into disarray just when we need more cooperation on issues like climate change. So the laws of every country put consumers into business with violent and corrupt and unaccountable actors in resource-rich countries, which gives them the power to be more unaccountable still. The very good news is that human rights law, rightly understood, requires accountability over natural resources. Human rights law requires just what's lacking today, which is accountability to the people of the country for the use of the country's resources. Any use of a country's natural resources must be accountable to the people because the resources belong ultimately to the people. There's only one human right that's affirmed twice in either of the covenants and both of the covenants, and it just is the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. The rights of people over their natural resources is clearly stated in the human rights covenants, and the covenants are in turn accepted by most states. 98% of the world's population lives in a country that has ratified one of these treaties. Majorities in every region of the world say that they believe that the country belongs to the people. That is a significant affirmation of the right of self-determination, of which the resource rights of peoples is a significant internal dimension. So I said international human rights law, when rightly understood, requires accountability to the people of the country for use of natural resources. The two treaty bodies who are in charge of interpreting the treaty have made many statements over the years that show that they endorse the people's resource rights, but they haven't yet put all of those ideas into one place to support these rights together. So, respectfully, we at Clean Trade have been encouraging the treaty bodies to state clearly and forthrightly that the peoples have rights over their resources. We've been researching and writing and engaging with the treaty bodies for some time, and that's why we're excited that Michael from one of the treaty bodies will be with us very soon. Let me say a little bit more about the specifics of the people's rights over their resources has been developed in international law for all of these years. In Article 1, both of the treaties say, all peoples may, for their own ends, freely dispose of their natural wealth and resources. In no case may people be deprived of its own means of subsistence. There's two types of peoples that this applies to. We've been hearing about indigenous rights in the previous session. Those rights are well developed. The rights that I'm interested in now are the rights of national peoples. So the rights of the British people, the Brazilian people, the people of Congo Brazzaville, the rights of all the citizens of the country, because they are the ultimate owners of a country's resources. It's the resource rights of these people that international law now should defend. And they have two dimensions, substantive and procedural. So for substantive rights, you can think of it as requiring both a floor and a wall. The floor is that resource revenues must be first used for the subsistence needs of the people. Government has to prioritize using revenues to meet the basic needs of citizens. The wall of people's rights requires that any benefits from resource exploitation go to citizens and not, for example, to corrupt officials. So states have to have priority for subsistence, and the priority has to be getting the resource revenues to the people instead of purposes. Along with substantive rights, there's also procedural rights required by human rights law. Transparency, the people have to be able to find out what's happening to their resources. They have to be able to participate in decisions that the government is making about their resources. And there have to be free and fair elections so that the people can ultimately say, we're holding you, the government, accountable for what's done with our natural resource endowment. So these are fairly robust rights that national peoples have over the resources of their countries. Again, we're respectfully encouraging the treaty bodies forthrightly to declare these are the rights that all peoples have to their resources. What would it mean for those rights to be respected? And we can go back to sustainability here. How would it be helpful for sustainable development for these human rights to resources to become part of international practice? And is it even feasible for these rights to be respected? On political feasibility, we at least have proof of concept. Brazil's Senate has already introduced a bill that would require Brazil not to import any oil from authoritarian countries, and also would require Petrobras not to make any new contracts with authoritarian and corrupt regimes. So proof of concept is there. It is possible for a state to have legislation that would do the right thing. Any state could pass such a bill. You can imagine what it would be like if a European Union or a North American country passed a clean trade bill and said, as part of our net zero 2050 plan, we will, in 2050, no longer be importing authoritarian oil. That would immediately raise the price of authoritarian oil in futures markets and give another strong signal that it's time for us to switch away from oil completely to the sustainable fuels of the future. He would also give a strong signal, a strong peaceful signal to the people of resource-cursed countries that the West wants to stand up for their rights peacefully, to say the resources are yours and we're not going to buy them from anyone who's taking them from you without accountability. And since we're at Lee Day, let me just add one more thought on the business and investment side. Is it possible for finance, business, actually to respect people's rights to their resources? It is. Amati Global Investors, which is a fund manager up in Edinburgh, uses the Clean Trade Index to judge the level of risk in every resource-rich country that business activity will actually benefit the people, or that it will rather strengthen oppressive and corrupt actors in that country. Amati's doing quite well with their index. They've got over £1 billion under management. It is possible to do good business while not contributing to the risk that the money going into the country will further encourage the resource curse. So the people of a country must be able to hold their state accountable for the state's use of resources. The power of oil, the power of natural resources is too dangerous to be left in the hands of a few unaccountable men. Unchecked power is too dangerous for investors, for businesses. It's too dangerous for the citizens of resource-cursed countries. And it's too dangerous for the billions of people around the world who depend on the world's supply chains to get them the resources they need to meet their basic needs. It always costs something to respect rights, here the people's rights. But in the long term, if we don't respect the people's rights to their resources, the resource curses will get worse, and we will end up paying in the long run. Thank you very much.
Presentation. I think there are many points that that will be interesting to discuss later on. Now, Michael is here. I'm very pleased to welcome Michael Windfuhr. We've already done a brief introduction, so I'm not gonna take your time up with that, but I'll hand over to you, Michael, now.
Yeah. Hello and have a good day. First, I have to say I'm not a native English speaker, so even if it is in London happening, forgive me that I'm always working in a foreign language when I'm working also in the UN level. You have asked me to maybe give 20 minutes on insights of how we are discussing in the committee natural resource extractives and sustainable development, also in the light of a general comment we are just writing on the relationship of economics, agricultural rights, and sustainable development. Can you hear me well, by the way?
Yeah.
Okay, that's good. And let me first thank you for the invitation, and I will say a few things to my person, which might be not fully in the introduction where I come from, but then I will explain you where the tricks and the problems are dealing with this and where we are thinking at the moment. And then you might respond to this, or we might have an open discussion. Yeah? So, as you know, I work for the German Institute for Human Rights. We have been very active in the agenda of business and human rights, and we have been in the back of, or backing at least the German supply chain due diligence law. So very much engaged in this process of getting German companies in their deep supply chain to respect better human rights, particularly also economic and cultural rights. I'm also a member of this committee, which is normally supervising states. We have just, for example, had Brazil here in the session, or France or Palestine, very interesting countries at that moment. And it was the part of Palestine, by the way, which is the West Bank and not the Hamas who were here. We are drafting general comments, as I've described, and we have also done already some general comments, just to mention, which are extremely important for our discussions here. We last year adopted a general comment on land and economic and cultural rights, which has a lot to do with the issues of natural resources, extractive industries. And we have also made a general comment 24 on business and human rights and the extraterritorial interests of states who have to control what their own business doing abroad. So both are of extreme relevance. So let's now dive into the issue, and I would like to differentiate 3 levels of discussion which we need to do. For example, as a Human Rights Committee, we can have a look when we supervise states, also when we have to look into concrete projects of, let's say, exploitation of natural resources, of investments into natural resources and resource extraction, mining and resource extraction. And there we normally apply the standards which we have by saying that the legally bound institution is the state itself. So it would be the state of Brazil, the state of Congo, Brazzaville, or others who have to make sure that any investment in natural resources is done in a way in full respect of economic, social, and cultural rights. Yeah, they should respect that the rights of peoples like indigenous peoples, but also other persons in their territory, are fully recognized, that, for example, during a mining activity, there is no deviation of a river or river water pollution, so that the right to water of people living there is not affected, that people are not forcibly evicted without getting any form of a compensation or resettlement. All this is a national obligation, and this should be normally done. The state has the right in many countries, also legally, but also institutionally, maybe to use natural resources, but it has to be done in a way accepting economic, social, cultural rights as standards. This is by accident not happening in many countries. There's a lot of violations linked to this, and it's often state-run companies who are violating these rights. It's often the state neglect of controlling private actors, which is at the core of a lot of problems with extractive industries. So we have to address this, because the main responsible remains the state. And that is also where the term of natural resource use we were just hearing can become problematic, because in our context, many states say natural resources are ours and we decide what to do with this. And how much we have to ask our own people is a second thing. So the reference to Article 1 of our covenant is often used by Russia and others for unlimited right to exploit their natural resources. And what happens with their people is a second point. Yeah, so it's a state-used argument to say that's ours and we use it and we don't have to give it to others. It's more our right to control it. So that is, in the way it is often brought forward, and it's extremely interesting to know, and we have to deal with this, that if we apply natural resource rights, we have to make it carefully that it can't be misused in this context. The second layer I want to present to you is the layer of resource extraction and mitigation. So what does it mean when state starts using the natural resources to an extent which maybe supersedes any option which is allowed under, for example, climate negotiations or biodiversity? We have here in the state, particularly those countries who are also already not bad in sustainability endeavors on their national level, but if you talk to them about their own resource extraction rights, you are having problems. We had, for example, a longer discussion with Norway, which is one of the best states in implementing economic, social, cultural rights, and which is the best state in having renewables energy available. But when we started asking questions, what is your impact of the new oil field in the Barents Sea, where Norway will extract petrol, fossil fuels, to a very large extent, to a much larger extent, their own resource use is at the level of CO2 emissions. They were extremely becoming furious, saying this is not the task. This committee might ask. That is an issue which is their right, and with this right, they are financing the pensions of their citizens. And at the end, when we were becoming back and saying, what do you are doing with these, let's say, amount of fossil fuels, if this is burned to the climate change and onto the, let's say, enjoyment of economic, social, cultural rights of citizens in other countries and your own citizens, they were then at the end saying, well, at least we are extracting the fossil fuel 50% more efficient than Saudi Arabia is doing. So we shouldn't be forbidden to extract these resources. The same answer we were getting from Australia, also not a country extremely bad in economic, social, cultural rights. So we were asking about the largest coal mine on earth, which has been started some years ago. They were equally angry with us. And it happened now also with Brazil, when we were asking, what do you do with the new ideas of Petrobras to extract petrol or fossil fuels from the ocean in the surrounding of Brazil? They were also saying this is not our task. So you can see when it comes to the real nitty-gritty and the income, states are actually saying our resources, natural resources, we can use them, no limit. And we are not willing to even discuss it with you. Yeah? So just to flag this as a bigger problem. And the third layer then on the whole discussion is, what does it mean to talk about the implementation of covenant rights if we might be in the need to limit the right to extract resources or to limit mineral use, limit fossil fuel use. And with that, maybe might also have in future reasons for maybe limiting the overuse of resources by certain states, but also the overuse of resources maybe by particularly rich persons or companies. So when we come to the planetary boundary, addressing these planetary boundaries, what does it mean? That means we have to rethink maybe the overall logic behind also the enjoyment of economic, social, cultural rights. If you look at our covenant, it has been drafted in the 50s and 60s years. In Article 2, it's saying, well, the states should use the maximum of its available resources to progressively implement or progressively realize all the rights enshrined in the covenant. And this has been long time seen as maybe an understanding where you can say the more growth you have, the better you can implement these rights. And when we are now starting to think about that, there are not so much rights or to resources left, and we have maybe to limit to stay in the planetary boundaries. That means we have to drastically discuss much more the right of having access to resources for energy, for water, for land, for food production, and that will entail also limitations of maybe the right to be just used by rich people, by companies, and so on. So it requires also to think about the distributional impact of resource use in that. So I have differentiated the three layers because they demonstrate where the discussions are here, which I observe. I think our committee is, when I come back to these three layers, is very good in describing what happens with the first layer of arguments. So we have developed a good jurisprudence, what states at the national level should respect, protect, and fulfill human rights when they use their own natural resources, in participation, transparency, in considering ethics and all this. So we can apply these standards, which I have already mentioned, for states using their own resources and respecting at the same time the rights of their own people. So this is the one level. There we have also developed. Pardon? No, we have also developed very good standards to describe what is the obligation to protect, so that states have to regulate private companies acting or using this. It can be national companies like Petrobras. It could be also international companies coming into the state. And I think the discussions which we have developed is also very helpful in saying you should regulate companies coming from abroad into your countries. And we have also developed very good, let's say, jurisprudence of where the extraterritorial obligations, so that states acting, for example, in multilateral development banks, in big financial asset companies, or maybe if they are having national companies investing abroad, that they should also regulate these activities so that in the long run that doesn't contribute to human rights violations of people directly affected. So all this we have developed, and it's still a struggle to get extraterritorial obligations always recognized, but that's where we have come quite far. And I think also the development of this understanding of human rights due diligence, and that the state party should have a national action plan on business and human rights, that you should have a binding law on human rights due diligence, requesting from companies along the whole supply chain to make sure that they don't contribute to human rights violations, are all steps in that direction to control this part of the coin. Yeah, we are much weaker to the second layer. What is the right of states to use their own resources and how this can be limited? There is no acceptance yet, as I told you, to let the international community or even human rights committees discuss their right to extensively use what they have, how even to sell it at the global market. This is really a substantive limitation, and this maybe is addressed in the UNFCCC, the climate negotiations, or also in the biodiversity conventions. There are rights on forms of maybe where through national determined contribution states are limiting themselves. But this is also not binding law like human rights law. It's not so easy to implement this. And we are struggling what to do when they are still continue and over-exploiting their resources, particularly, let's say, in their impact in the long run on climate change, biodiversity losses. So this is an open issue. And the third layer, we are just at the beginning. We are writing this general comment at the moment, which tries to link the status of state obligation under the Covenant of Economic, Social, and Cultural Rights to the triple planetary crisis, to say, what does it mean to implement human rights in a world where planetary boundaries are more and more limiting our possibilities to, let's say, invest into certain areas where we need to restrict, or we have to live at least in limited resources. That means also we have to guarantee that any limitation we impose to states or to at national level needs to be imposed in a way that it doesn't violate economic, social, cultural rights, particularly of those who are marginalized or living in deprived conditions. So limitations in the resource use can't be used to be retrogressive on the enjoyment of economic, social, and cultural rights. That is the first which needs to be understood. But that might also need that you have to limit the resource use of others who are extremely overusing the resources they have at the national level. So this is the national discussion of this, and you can also have it at the international level. So how much we have to reduce maybe the overuse of resources in countries like the UK and Germany in order to have a more equity in the resource use at the global level. So if you would follow the calculations, nobody should use more than 2 tons of CO2 emissions per year. We are far away from having this achieved. There are countries on Earth which use much less resources, while we use in the average in Germany 11, in the US they use in the average 22 tons. So we are so far away from this. And if we go into this discussion now, what does it mean to guarantee economic, social, and cultural rights for all people in each country, but also globally, then we have also to start discussing this much further. What does it mean in terms of access to natural resources? So I've described the threats which I see in the debate, where we are, what we have achieved, what we could build on, and where we have also helped indigenous communities and other peoples defending their economic, social, cultural rights, maybe against the threat for natural resources. I have also said land rights and the rights of peoples can be strong defense arguments. That, I think, is the idea which you have presented before me. And we can dive more into this because the new general comment on land and economic, social, and cultural rights builds on this. So how to defend is much stronger. But I have also described how many states are acting. And there is a substantive resistance here to accept this type of interpretation on access to natural resource rights. And so at that level. And then I have discussed the equity issues, which are linked to, let's say, all modeling through planetary boundaries in our calculations. I hope it was a useful start and input to your discussion. I think that's where we are at the moment, at the front line of, let's say, developing international human rights law in order to realize economic, social, and cultural rights, but also at a sustainable level. Thanks.
Thank you very much, Michael. That was very insightful and very, very interesting. And I think we'll move on now to the next 2 speakers. And after having had 2 contributions looking at the interplay of natural resource extraction and sustainable development from perhaps a more general perspective, we will, and perhaps also focusing a bit more on the responsibility of states in hindering or helping these issues. We're now going to hear about 2 concrete examples where people's rights are impacted by natural resource extraction, where they aren't able to enjoy those natural resources fully and freely. And the role also of corporations, a bit more about corporations in this context, as well as the notion of sustainable development and what that actually means for the affected communities. So first of all, I'd like to hand over to Kavita.
Thank you, Katerina. So I'm going to talk today about litigation that LIDE is bringing on behalf of 2 communities in the Niger Delta, the Bele community and the Agale community. Do we have the slides, Judah? Thanks. And then I'm also going to touch a little bit about a climate change case that's been brought in the Netherlands, and then very briefly about sustainability when it comes to the Niger Delta. So firstly, just to introduce the topic of the Niger Delta and Shell's involvement. Shell began their operations in Nigeria whilst Nigeria was a British colony. Their operations there have been going on for many decades, and their operations and the operations of other oil companies has caused wide-scale pollution in the Niger Delta. It's been called one of the most polluted areas on the planet. And even though people are living with this very valuable natural resource under their feet, there is wide-scale poverty and very high levels of unemployment in the region. Meanwhile, Shell is making a huge amount of profits, but they are now seeking to leave the Delta, at least their onshore activities, and they appear to be intending to do so without cleaning up the legacy of their activities over so many decades. So this is a picture of part of Bilay. Bilay, as you can see, is a riverine area. It's in a remote part of the Delta. And people in Bilay have historically made their living from fishing. Fishing has been an intrinsic part of their way of life. And historically, people have had a relatively comfortable life because fish were abundant in Bilay, and Bilay was renowned for its fish. And even those people who didn't maybe have a job could always go to the waterside, pick some shellfish, be able to create a meal for their family. So they were in a relatively good position, but that has now all changed. So between 2011 and 2013, there were a series of spills which have devastated the environment. The environment in Bilay is based around the mangroves. So there are many mangroves by the waterside, and this provides a habitat for fish and shellfish. But the mangroves have been damaged or killed because of the oil pollution, and people find that they can no longer make their living from fishing any longer. And the scale of the change to people's way of life can't really be underestimated. Previously, almost everybody...
La gente no se puede subestimar.
Previously, almost everyone made their living by way of fishing, but nowadays, very few people are able to make their living in this way. And they've had to find different occupations. Many people have had to move to the city in order to make ends meet. And the scale of the pollution and the impact on the people in Bilay can't really be overstated. People have told us about when the tide is high, the water coming into their homes, bringing oil with it right into their homes and damaging their possessions. Other people have told us about oil seeping through the floor of their homes. It's coming into their kitchens. People are scared to use their kitchens because of the fire risk. It's a really drastic effect on people's lives in Bilay. And the other community that we are acting for is the Agale community, which is very different than the Bilay community. It's a rural farming community. And you can see there a couple of pictures of some of the wells in Agale and a sign telling people that the water is contaminated. And that is because in Agale, there is an aquifer underneath Agale, and this is the source of people's drinking water, and this has been contaminated. In 2011, the United Nations Environmental Programme published a report of their studies, and they had done testing of the groundwater in Igale and found levels of toxins in the groundwater that were hundreds of times above the levels that are permitted under Nigerian law. And the water, they said, was not safe for human consumption. So there was a period when Shell were providing people in Igale with clean water, but that is unfortunately long gone. And people in Igale are unable to get access to clean water unless they're able to afford to buy it. And sadly, this is the same situation in Bile, where the water is also contaminated. People don't have access, many people don't have access to clean drinking water unless they have the means to buy sachets of water. So the litigation that we're bringing is in the English High Court, and it is litigation against Shell plc, which is the UK parent company, formerly known as RDS, or Royal Dutch Shell, and the litigation is also being brought against the Nigerian subsidiary, which is called SPDC. And there are a number of different claims that are being brought. The claims against Shell plc, the parent company, are being brought in negligence, and this is being brought on a number of different bases, but basically that Shell were aware of systemic issues which were causing multiple spills to occur in both Bile and Igale. And that is around a couple of different things. One is the failure to maintain their pipelines in a proper state, or to maintain and repair them, and also a failure to protect their pipelines. In the Niger Delta, there is a very well-known issue of bunkering, which is the theft of oil, so people tapping into the oil pipelines and stealing oil and being able to use that in refining elsewhere. Now, Shell are very well aware that this occurs, so we say that they should have taken steps to protect their pipelines to stop people being able to do this. So they could have buried their pipelines deeply, they could have encased their pipelines in concrete, they could have taken proper steps to make sure that they could monitor and detect when spills were occurring. And these are all steps that they do in other parts of the world, but they haven't done that in the Niger Delta. The claims are for compensation, but also for cleanup. So this is asking the court for an order that Shell be required to take the land and the water in Bile and Igale back to the state it was before this environmental devastation occurred. So the claims were started in 2015 was the earliest one, and they've been going on so for almost 8 years. But they haven't yet reached a trial, and we don't yet have a trial date. And the main reason that it is taking such a long time is because Shell spent many years trying to prevent the cases from being able to go ahead in the English court. So Shell said that there was no arguable case that the UK parent company was responsible for pollution in Nigeria. This went to the High Court and then the Court of Appeal and then the Supreme Court. And the Supreme Court ruled in February 2021 that actually there was a good arguable case that Shell plc, the parent company, was legally responsible for the pollution caused by its Nigerian subsidiary. So Shell are fighting this case pretty hard, and they have a number of different arguments. Essentially, they accept that the area is polluted, but they say they are not legally responsible for this pollution. They say they make this case on a number of in a number of different ways. They say the spills occurred too long ago, or at least some of them did. So even if the oil is still there and hasn't been cleaned up, they say, well, tough luck, you can't do anything about that. Secondly, they say that they have no liability where bunkering has occurred. So they say, they are not responsible for any of the spills that have occurred in this way. And according to Shell, many of the spills have occurred in this way. That's, I think, a question of evidence, because we would say that their reporting about the cause of the spills is not reliable. So there is also a question of how have those spills been caused? Are they spills that are caused by the corrosion of the pipelines, operational issues, or are they caused by bunkering or other activities of third parties? Then they say that only the Nigerian regulator can force a cleanup. So they say that our clients, even though they are the ones that are impacted, can't bring a legal action saying that Shell must clean up the oil. The Nigerian regulator is unfortunately pretty under-resourced, but Shell say, well, that's that just isn't an option for your clients to be able to bring this kind of claim. Can't get it to.
I'm not sure, I don't know.
Okay.
You just.
I'll keep going. So the claims are now in a kind of trial preparation stage, but we don't yet have a trial date. And unfortunately, Shell's main tactic seems to be to delay. This is a picture, thank you, Judah. This is a picture of the Awoba flow station. That's one of the flow stations in Bilé. So Shell are trying to delay the case in a number of different ways. One of their arguments is that there should be all kinds of different trials of different issues before we get to a trial of the liability of Shell PLC, the UK parent company. So this seems to be pushed into the never in the hope that we don't get there. Obviously, this is all stuff that we are arguing about, and it's for the court to decide how the case is going to proceed. I wanted to talk very briefly about the Milieu de Fancy case that was brought in the Netherlands about climate change. And this was brought in the Dutch courts. And in May 2021, the court gave a really groundbreaking judgment. They said that Shell should be ordered to reduce its CO2 emissions by net 45% in 2030. And this included both the emissions from its own operations and emissions from the use of the oil it produces. Shell has, not surprisingly, filed an appeal about this, but the court found the obligation to reduce emissions from a duty of care in the Dutch Civil Code. The judgment is quite interesting. It also talks about things of more general application. It talks about the risk that climate change poses to human rights. And it talks about the UN guiding principles and the responsibility of businesses to comply with those principles and with those standards. So I know the topic of the panel is about sustainable development, but unfortunately, when it comes to Shell and the Niger Delta, I think it's difficult to say very much that is positive in this regard. Shell has lots of, fancy graphics on their website where they talk about the commitments, what they're doing towards the UN Sustainable Development Goals. But at the end of the day, in terms of what we can see, our clients are not even being provided with clean drinking water, which I would think is just a very elementary part of sustainable development where this kind of pollution is known to have occurred. And then I wanted to leave you with a quote from Ken Henshaw, who is the executive director of We the People, which is an NGO in the Niger Delta. And Ken talks about the just transition and green jobs, and he says that this is very different in the Niger Delta than it is in the UK and Europe, because what jobs do the people of the Niger Delta have to go to? Their way of life, being able to make their living from fishing or farming has been destroyed. The environment has been devastated. So he says that before a transition, there has to be justice. He talks about reparations and the colonial context in which Shell first started their operations. And he says that reparations must involve a cleanup of the years of oil pollution and restoring the environment to the way it once was.
I think that quote gave perhaps some interesting points for discussion later again. Now, I'm very pleased to welcome our last speaker, Rosa Maria Mateus. She should be here with us now on the screen. And yeah, I think she's here. So we'll hand over to her straight away. Rosa Maria, we've already done introduction at the beginning, so we'll, yeah, we can jump straight in.
Hola, buenos
Hi.
días para todos
Hello
y
to
para
everybody.
todas. Un gusto estarles
It's a
acompañando
pleasure to
en
be
esta
with you
sesión.
in this session.
Bueno, para iniciar,
To start,
quisiera
I'd like
primero
to,
advertir
well,
y
first of all, just point
comentarles
out and tell you
de
that
la experiencia
the
que desde
experience that
Cajar hemos
from
tenido
Kahar, that we've had at Kahar,
no es nada diferente a lo que
is
ya
no
han
different
venido
from
escuchando,
what you've
sobre
been
todo
listening
frente
to,
al caso de
above
Shell.
all about the case of Shell in the
Voy
Niger
a
Delta. I'm going to
presentar rápidamente
present,
unas diapositivas
I'm going to
para
present some slides
ubicarnos
just to
en
locate ourselves in
algunos
the
conceptos
contextualize
o
ourselves
puntos de
or
partida
provide some
mejor
concepts or some
que
starting point is a better way
hacen
of putting
parte
it,
de este caminar que nosotros hemos recorrido en
to
casos frente
contextualize us in terms of the work
multinacionales
that
o
we have been
transnacionales.
developing in relation to multinationals,
Pero
transnationals.
ahora,
But it seems that, oh
compartir
yeah,
pantalla.
I think I can share my screen now.
Bueno, ustedes
So,
van a ver
you are
aquí
going to see here
textos en
some
español,
texts
pero
that are in Spanish, but
solo quisiera
I just wanted
en
to,
estos 5 minutitos
just in the 5
presten
minutes,
atención a las
for the next 5
imágenes.
minutes, I just want you to look at the images,
Para
really.
nosotros es muy
For us,
importante los
it's
puntos de
very
partida
important, the
porque
starting points.
hay
These starting
ocasiones
points are
en
very
los
important
que en
because
estas
at
discusiones
times in these
se nos
discussions,
tacha por
we
parte de los
are
gobiernos
accused by
y de la
governments
institucionalidad
and by
como
institutional life in
personas
general, the institutions in
radicales
general,
en
as
estos
radicals
diálogos a propósito
in the dialogue that we, in our
de
positions in the
los
dialogue that
derechos
we
humanos y las
are
empresas.
involved in relation to
Nosotros
business and
estos
human
puntos de
rights.
partida los hemos
These
construido alrededor
starting
de 20
points
o más años
we
de
have
trabajo
developed
con
as a result of
comunidades
20 years
afectadas
more
por el
working
extractivismo.
with communities who have been
Esta
affected by
imagen del
extractive
cuento de la
activities.
ranita
This
y el
image
alacrán
from the
o el
story about
escorpión nos lo
the
dijeron
frog
en
and the
alguna
scorpion,
ocasión
this
en
is
una
a
comunidad.
story that a member of a community told to us. And it's
una ranita
a story that tells
río,
about a frog that
un
finds itself
escorpión
on the
llega a
edge of a
pedirle que
river,
la
the banks
pase
of a
al
river,
otro lado
and
del
the
río.
scorpion asks
Pero
the
la
frog to
ranita le
take it
dice que
across to
no,
the other side of the river.
no
But the
porque
frog
la va a
says,
picar.
no, I won't,
Pero
because
el escorpión
you'll
le
sting me.
insiste hasta
But the
que la
scorpion
convence.
insists until
La ranita
finally he
se
convinces the
deja
frog, or it
llenar
convinces the
de un
frog.
montón de promesas.
So the
El
frog
alacrán
listens to all the promises that
le pide que la lleve.
the
Y cuando
that the
ya
scorpion
van
has
llegando a
made
la
it
otra
in its
orilla, el
urgency to
escorpión
cross the
la
river.
pica.
And when he gets to the other
Y
side of
la
the river, the
ranita,
scorpion stings the frog.
ahogándose,
And
le
the frog,
dice,
dying in the water,
escorpión, ¿por qué
drowning,
me
says, "But
picaste
scorpion,
si tú
why
me
did you sting
prometiste
me
que
when
no me
you
ibas a
promised that
picar?
you wouldn't
Y el
sting me?"
escorpión se
And the
voltea
scorpion
y le dice,
turns
lo
around
siento
and
mucho,
says to the frog,
ranita,
"I'm
pero es
sorry,
que es
frog,
mi
but
naturaleza.
the thing is, it's my nature." I'm a
La
scorpion.
naturaleza que nosotros
The
hemos visto
nature
en las
that
empresas
we
en
have
las
seen, the
que,
nature of
frente a
companies
las
that
cuales
we
hemos
have
litigado,
seen
no
in the
son
case
los
of
derechos
companies that
humanos.
we have
La
litigated against,
naturaleza de esas
their nature
empresas
is not
es
a human
el
rights
interés
culture.
económico,
It's
es un
economic,
interés que
right,
está
economic
muy
interests.
distante de
It's a
lo que las
series of interests that are
comunidades
very,
buscan
very
en sus
far
territorios
from
y
what
es
the
muy
communities are
distante
looking
frente a
for
las graves
in their
situaciones
communities.
de
And it's
derechos
very
humanos que hemos
far
visto.
from the grave situations of
En
human rights
esta
violation that we
situación
have
se ha
experienced.
valorado y
So in
evaluado
this
la
situation,
captura
we
corporativa,
have evaluated, we've looked at
la
corporate capture,
interferencia de la
the
industria en las
interference
políticas
of industry
públicas,
in public
en
policies,
la
in the
discusión
design of public
alrededor de
policies, in the
leyes.
discussions
Sí,
about
hemos visto
laws,
cómo hay un
about
lobby enorme
legislative
y todos los
proposals. There's an
dispositivos de la
enormous
captura
lobby.
corporativa se
So these
hacen
are a series of
posibles.
slides about
También nos hemos
corporate capture
encontrado
of
con unos
the state
abusos
and
de
of the
poder
institutions.
y estos
We've also
abusos de poder
documented
están
abuses of
concentrados
power,
desde las
and these
normas,
abuses of power
desde
are
los
based in
discursos,
the or
desde la
based on
omisión
the normativity,
institucional,
the
desde
legal
la fuerza
frameworks, on the
física. Por
institutionality
ejemplo,
of the
Colombia se
rules of the
ubica
game
en uno de los
in
países
which
más
things are
peligrosos
done
para la
in Colombia.
defensa
For
del
instance,
ambiente
Colombia is one of the most
y
dangerous
la
countries for
negación de la
environmental
participación.
protection, and there is a systematic denial
Para
of
quienes no lo han
participation.
visto,
For
nosotros
people who haven't
recomendamos
seen
mucho este
this film, we
documental
do very much
porque
recommend
deja
this
ver
documentary
mucho
because
de lo
it
que
gives
enfrentamos cada vez que
an
hablamos de estos
excellent
temas.
image of
La
what we are
utilidad
talking
pública
about.
también es un grave problema en estas
Public
discusiones
utility is also a question. The
y la
idea of public good, of
participación
public
de estas
utility,
comunidades
and
en
participation
todas
of the
estas
communities
problemáticas.
in all of the
Funciona como
problematics
el
that they
cuento
face.
del
This
cocinero y la
operates
gallina.
with the same story
Es
in a
un
story, or is
cocinero que
exemplified by the
reúne
story
a
of
todas
the
las aves
cook
del mundo,
and
reúne a
the
los
chicken.
patos,
This is
a las
a cook who
gallinas, a
gathers
los
together all of the
faisanes, a los
birds,
pavos, y el
ducks and
cocinero les pregunta
hens and
con qué
pheasants,
salsa quieren ser
and he
comidas.
asks what
Y
sauce they
una
would like to
gallina
be
da un paso al
prepared for
frente
us
y
to eat
dice,
them
pero
in.
es que yo
And a
no quiero
chicken
ser
passes
comida.
by, but the chicken
Y el
says, "Well, I don't
cocinero
want to
le
be food at
dice,
all."
no, no, no,
But
eso
the chef
está
says, "No,
fuera
no,
de la
no, you
cuestión.
don't understand. That's
Así
outside
está
the discussion.
funcionando la
The question
participación de las
is, what
comunidades
sauce do you want me to
en
cook you in?"
la
This is the
decisión
way that
frente a
the
lo que
discussions are
quieren o
taking
no
place,
que
or that
ocurra en su
consultation
territorio.
takes place with communities. They are not
Hemos ido
involved in
y
discussions that
atravesado un
affect their
camino de
futures.
muchísimos
The terms of the
instrumentos
debate are not their terms of
alrededor
debate.
de este tema de
We've
empresas y
also been
derechos humanos.
focused on this
Desde las
question of business
discusiones
and
en
human
Naciones
rights.
Unidas, que por
We've been
supuesto se han
involved
dado
in the
desde hace
discussions in
ya,
the United
desde los años
Nations that have
70,
been conducted
alrededor
in
de
the
los
UN since the
principios rectores,
1970s. We've
de
been
las
involved
leyes
in
de debida
discussions around the guiding
diligencia,
principles
de la
about due
responsabilidad social
diligence, about
empresarial,
social,
desde los puntos
corporate
nacionales de
social
contacto,
responsibility, about
ahora
the
las
national
discusiones
contact
del
points.
tratado
Now we've
vinculante
been involved in the
y
discussions about the binding
hemos,
treaty. And in
digamos,
all of this experience
actuado
that we
frente a
have over the
todos estos
years, we have
instrumentos
acted in
sin
relation to all
encontrar
of
que la
these
realidad
interests without
cambie para las
noticing
comunidades, sin
any change
encontrar
in the
que estas
realities faced
empresas
by the
asuman
communities.
responsabilidad.
We haven't
Y
seen any
finalmente nos
evidence that the
encontramos
companies are
contra el
assuming their
sistema
responsibilities.
del
And
CIADE, ¿no?
finally,
Los
we
tribunales de
are finding
arbitramiento
ourselves
internacional,
in the
donde
face of
estas empresas
CIADE, of the
vienen y
international
demandan a los
arbitration
estados
tribunals, where the
ante
companies
cualquier
um,
situación
t-
de cambio.
um, demand
Bueno, pero el
take out legal
panorama,
cases,
como lo advertía
sue
Marcos,
countries
pues
for because of
es
the
bien
legislative of the
desalentador frente a la crisis
environmental protection
climática,
legislation that they're
frente a
seeking
esta
to
crisis
develop.
civilizatoria
So,
en la que nos
given this
encontramos.
crisis in
Y
civilization that
nosotros
we are
también
facing,
hemos
this environmental
logrado
crisis that we are facing,
determinar
we
cómo en
have
el
also
mundo se está
been
hablando de
able to
transiciones, pero
we
siguen
have noticed
siendo
how in the world,
transiciones
at world
muy
level, the
colonialistas,
conversation is about
porque no
transition, but
atienden a lo que realmente las
we're aware that
comunidades
these
pretenden.
transitions remain
Este
imperialist
es un
transitions because
panorama
they're
que
not
nos ubica en
responding
una
to
real
what the
disputa
communities themselves
por la
are
verdad.
looking for. This is a slide that
Incluso
shows the
con
reality that
IPEI
we
también
um,
intentamos
are
trabajar
that we're
en una
facing.
demanda.
This
Aquí tenemos
dispute,
una muestra.
in
En
particular,
esta
that I'm showing you, this is
fotografía
an
ustedes
example
ven
where you can see in
una
the photograph on
publicación
the
de la
left.
empresa
This
que
is a
creo hace
publication published
referencia a
by the mining
quien me
company in this part
antecedió
of
en la palabra
Colombia.
contaba de Shell. Ellos
with
en sus
this.
páginas se muestran
This is
absolutamente
very much
verdes,
similar to what the woman
responsables,
who spoke
cumplidores de
before
un
me.
montón de deberes,
It's very
pero
similar to what
realmente lo
Shell
que
does on
nosotros
its website.
encontramos
This is
es
an image of
esto,
the river that they
¿no?
produce,
El
but in
cambio de
reality, these images
paisaje,
on the right are the
todos
realities
las
that
afectaciones
faces
en
the
un
communities that
ecosistema
we're working
cuando el
with.
tajo minero
This
va
is
aumentando,
the
aumentando. Este es
effect, the
una
environmental effects
fotografía
of
de
the
un caso
expansion
muy
of the
emblemático para
open cast
nosotros, que es
mining
el caso del
activities
Arroyo
as they
Bruno,
develop. This
en
is a
contra
case
de la
called the
empresa
Arroyo
Carbones
Bruno
del
in the
Cerrejón
Cerrejón
de la
mine,
multinacional Glencore,
which
y
is
que
owned
hace
by
poco
Glencore
BHP
Mining, and which
vendió
until
sus
recently
acciones junto con
BHP
Anglo American.
sold, BHP and Anglo American sold.
Aquí
They
en
were,
Colombia
it was a joint
también se ha
venture, but they
hablado
have
de
now
la
sold, Anglo
necesidad
American and
del
BHP have now sold their
decrecimiento,
shares
pero
to
esto
Glencore.
aquí parecía un tema
And they are
intratable. No
greenwashing.
se puede hablar de
But this
decrecimiento.
question of
Por ejemplo, salió esta nota que una
the
ministra aquí habló
responsibilities
del
that the
decrecimiento, inmediatamente todo el mundo
Glencore
dijo,
is saying
eso
that they're going
no
to
tiene
withdraw, that they're going to decrease their
no tiene un
activities.
respaldo,
But this is an
digamos,
image of
alrededor del
the
tema, cuando
Minister
pues es de
of
lo que justamente
Mines
tenemos
who
que hablar,
says that
porque
the
son los
government
niveles
does
de
not
consumo,
support,
son los niveles de
is not
explotación
supporting
los que nos tienen en esta
reduced
situación.
consumption because Colombia's model is based on
Bueno,
extraction. So
ahora,
now,
creo que
I
me
think
puedo
that
ubicar en este mapa. Esta es La
this
Guajira,
map, this is La
donde
Guajira,
queda
which is in
ubicada
the
esta empresa
northeastern
Carbones del
part of
Cerrejón, que es la que quisimos
Colombia,
traer como
and that's
ejemplo,
Cabo de la Vela
porque hay
in the Amazon,
muchos
in the
ejemplos, ¿no?
Caribbean, just next to
Si ustedes ven este
Venezuela.
mapa,
So
la
as you can
mina
see
de
on this
carbón
map,
es esto.
the coal mine is
Este
this
pedacito
bit down in
por la
the that
línea
I'm
férrea, y
indicating
desde acá
down at the
sale el
bottom
carbón
with the
hacia Europa
railroad,
y
a
hacia los
railway
países que
that
compran
takes the
este
coal
carbón.
to the
Entonces,
port
aquí hay
from
muchas
where it
comunidades
goes, where it's
indígenas,
transported
pero en
to
un mapa se ve así,
Europe.
¿cierto? En La
This whole
Guajira
area
es
is
esto.
the area
Esto
that
es el
is
Tajo minero.
inhabited
Y
by
este puntito
indigenous
rojo
communities,
es
but
una
this
comunidad
is the reality. And this
que
red
está
point
todo
here,
el tiempo
that is an
respirando
indigenous
el aire
community that is
contaminado,
still
que
every day of
no
their
tienen
life,
agua
the
potable, luego
population is
consumen el
breathing
agua
in the
contaminada
contamination.
también.
They have
Y esto
contaminated
lo ha
water
dicho ya
sources,
múltiples
and this has
sentencias
been
de la Corte
said
Constitucional
several
colombiana. Ha
multiple
declarado
judgments
la
of the Colombian
responsabilidad
Constitutional Court
y
has
de la empresa y
recognized and
del
declared
Estado
the
en más de 15
responsibility of the
sentencias
company
judiciales.
and of the state in more than
Nosotros desde el
15 judgments
colectivo
that have been
podemos
handed
decir que
down
hemos
by the
ganado, entre
Constitutional Court.
comillas,
We as the
sentencias.
collectiva can say that we have
El
won.
problema
We have been
es que esas
successful in
sentencias
winning favorable
no tienen
judgments,
unas
but the problem
órdenes
is
fuertes
that the
o
judgments
contundentes y la
are not
realidad de estas
attached to
comunidades no tanto.
enforcement, powerful
Entonces,
or
más bien del
strong,
caso Arroyo Bruno,
serious enforcement rules. This is
esta
the
es una
case of
zona
the
muy
Arroyo Bruno.
de una
This is
escasez
an area
hídrica muy alta
where there is
y
a
la
this is an
empresa ha
area where
destruido más de
water levels are
18
where there's a great
arroyos o
scarcity
fuentes de
of
agua.
water. More than
El
18
arroyo
water
Bruno
sources
es
have
el
been destroyed
cauce
by the mining
principal
activities
de
of
un
Cerrejón.
único
The
río
Arroyo
muy
Bruno
grande que es
is
el
the
río
principal
Ranchería.
river, is
Lo
the principal
desviaron
tributary of
para
the
poder
Rancheria
explotar
River.
el carbón y
They
que el tajo
they
minero
diverted
continúe
it in order to
creciendo
be able to
y eso
continue,
tiene un
as you can see in the
efecto
bottom image, in
sifón.
order to continue their
Y
mining
creemos que,
activities. And this
no,
has
y ya
led to
técnicamente, digamos, está
a
demostrado
siphoning
que las
effect where the water is
afectaciones
being
por
abstracted
este
out of
desvío y por la posible
the whole catchment
explotación del
area.
arroyo va a causar más problemas con
This
el agua y con el
rerouting of the
ecosistema.
river and the mining activities
Sin embargo,
will
la
cause
empresa
further
insiste en su
dramatic environmental
responsabilidad
damage.
social
But the
empresarial.
company
Ella
continues to
insiste en que
say that
cumple
it is
con los parámetros, con
fulfilling
los
all of
estándares.
the parameters and
Ella
international
insiste
standards, that it
en que
is
hace
a
un uso
corporately responsible
responsable del agua.
company. It says that it's
Insisten en que
responsible,
tienen buenas
that it is
relaciones con
exploiting
las
the water
comunidades
in a
vecinas, en que
responsible way, that
salvan
it has
fauna
good
y flora.
relationships
Entonces
with
aparecen
the
notas como esta,
communities, that
de
it
que
protects
salvamos un
fauna and
tigrillo,
flora.
tenemos
They
un
say we
zoológico
have
y lo hemos
saved
rescatado.
we
Pero
protected
¿cuántos
this
tigrillos mueren
jaguar,
a
but
causa
how
de las
many jaguars have been
explotaciones?
killed as a result of their mining activities? This
Muchos.
is one that they did
Entonces, no se
protect, but many
comparece
more have
con la
died as
realidad.
a result of
Esta es la
the
realidad que
mining
muestra una
activities.
empresa como
This is
esta
the truth, in
y
inverted
esto es lo
commas,
que
that the
nosotros
company
encontramos. Por eso hablamos que
proclaims,
estamos en
but
una
these
disputa por la
images are
verdad.
what we find when we are
Los
in the zone.
arroyos
And this is the
absolutamente
subject
secos,
matter of the dispute.
contaminados,
the rivers are
Nosotros, a
dry,
diferencia
have
de ellos,
dried, or they're
encontramos
contaminated.
cerdillos muertos.
We find
Nosotros encontramos que a
we
las
find big
comunidades les
cats
llega el agua
that are
potable
dead
así.
rather than
Entra
alive.
un carro
This is the
tanque cada
drinking
15
water
días y les
that
da unos
we
litros de
find in the
agua.
communities, where there's a
Hemos
water
encontrado
tanker turns up
comunidades
every
que
2 weeks, and
señalan
this
el
is the amount of
Cerrejón
water
no
that
es
communities
bueno, ¿sí?
have to drink.
Y así
These are the
muchas
demonstrations that
situaciones
show that Cerrejón isn't a good neighbor.
complejas que se dan en un territorio donde hay una
These are just an
multinacional que ha
example of the very
explotado carbón
complex
más
situation
de
that communities
45 años
face
y estas
when they are
comunidades
neighbors to a
son
company that has
de
been
las
exploiting
más
coal in their
empobrecidas
area for the last
en La
45
Guajira, en
years.
el
But these
país.
are the poorest
En esta
communities in La
región
Guajira, the
mueren
poorest
más de
communities in the
5.000
country.
niños
More than
en la última
5,000
década de
children
hambre y
have
sed.
died of
No hemos
hunger
encontrado la
and thirst
conexión
in the
entre
last decade,
esas
and we have been
muertes
able to demonstrate the
que
relationship
obviamente
between
tienen múltiples
these
factores,
deaths, which
pero
obviously are
sí hemos
caused by
encontrado
multiple
una
factors, but
relación
we have been
con
able to
la pérdida de
demonstrate
soberanía
the
alimentaria,
the
con la
connection between
contaminación, con el efecto
between the loss
sifón
of
de
security of
los
tenure of
tajos
land tenureship
mineros que chupan el
and
agua que estas
and
comunidades
the
deberían
of
estar
food and
usando,
of
y
safe
con lo del
water
tema de la
and food
pérdida de
supplies and the
tierras
mining
fértiles
activity,
que
um,
luego ya
the
no
loss of
son
fertile
más despensas
lands
agrícolas
which no longer are
para
able to
estas
produce the
comunidades.
crops that the
Y
communities used to
gente
produce
en
on them.
resistencia diciendo
And
no
we have
queremos más
people in
minería de carbón
resistance
en
who
nuestro
are
territorio.
resisting the
Pero
mining
de otra
activities, who say
parte,
that we
uno
don't want
podría
to have more
pensar en las
mining activities in
preocupaciones
our
que
zone.
surgen
But
sobre
another
qué va a pasar con
aspect
los
is
empleos, qué va
the
a pasar
question,
con las
even though there is opposition
regalías
to the
que el
mining
carbón le da
activity,
al
there
país.
is concern about what will happen to employment. The
Pero
mine
son
does
cosas que
employ
tenemos
people.
que ir
What's going
dialogando
to
y
happen with the
solucionando ya,
royalties that
¿no?
the company
¿Y
does
qué
pay
hacer?
to the
Pues
country? It's
nosotros
true.
hemos
So what to
encontrado
do
que
with the transition?
definitivamente es
What to
necesario
do in
ver
order to
cómo
rectify the
desde
damage
las
caused?
diferentes
So what can
alternativas
we do?
damos una
What we need to
solución a
do
todo esto
is
que
to
está
base
pasando.
our future activities on what the
La
communities want, on what the
permacultura,
communities need.
la
We have
economía del bien
solutions such as
común, la
permaculture.
forma
We've got an
como
economy
están
based
actuando
on
los
the common
gobiernos,
good.
es algo que tenemos que ir
This
evaluando.
is what
Este
we need to
documental
be
que se llama El
developing.
filo de la
This
democracia
documentary, which
es
is
un
called On
reflejo
the
de
Edge
cómo
of
nuestros
Democracy,
países
this is
realmente
a
no son
reflection of the way
soberanos,
in which our
cómo
countries aren't sovereign.
realmente están,
This is a Netflix
están
documentary that
capturados e
shows
incluso
that
se
our
convierten en
states, that our
estados
countries have been
corporativos
captured by the corporate sector, that they have effectively
cuando
been
no
transformed
prima la democracia,
into
cuando no priman las
instruments
políticas
of
públicas en favor de los derechos de las personas,
corporate
sino
interests,
que
where
priman
they
los
don't take
intereses
decisions that are
económicos
based on but on the
de ciertos
economic
grupos.
needs of companies.
No sé cómo voy de
I
tiempo,
don't know how I'm doing for time,
pero bueno, era
Yeah,
lo que...
but
you were able to wrap up. Yeah, just to make sure that we have a little bit of time for questions.
Ok.
yeah, okay.
Entonces, todas este caso de
So
carbones del
this
Cerrejón
case of the
nos ha
Cerrejón mine
permitido ver
has
muy
permitted
en
us
el
to
detalle
see,
y
enabled
muy
us
en
to
la
see
filigrana
in great
cómo
detail
todos los
the ways
instrumentos
in
que
which
van
all of
surgiendo
the
alrededor de la
instruments
responsabilidad
that
de
have
las empresas
emerged
no son
in this
efectivos,
area of corporate
no
responsibility, that they are
reflejan un
ineffective.
cambio en las
It has
realidades
shown
del
that they're
mundo,
not
justamente porque
reflected in
existen
changes in
esos
the
abusos de
reality lived
poder,
on the
existe la
ground, because
captura
the abuses of
corporativa
power and the corporate capture
y muy a pesar
continue
de que
to
se
rule
logren
the day,
pactos
despite all of
jurídicamente
these
hablando,
international measures. And
no
even
vamos a
though we
encontrar
are
un cambio en las
successful
realidades de
in
la
the
gente
courts, we're
hasta
not
que
confident that this will
realmente
lead to a
empiecen
change in
a
the reality
operar o a
lived
funcionar
by
unos
the
sistemas
communities
que
until
dejen de ser
a
voluntarios,
system
que se
really
conviertan en
develops,
vinculantes y que
until we have a
sigamos
system
insistiendo
which
en
isn't
incluso la
voluntary but that is
responsabilidad
binding.
penal que
We need
corresponde
binding
a estas
instruments, and we
empresas y a sus
need true
directivos
legal
cuando estamos
consequences
frente a
that
graves
affect
vulneraciones de
senior
los derechos
management
humanos.
of these
Las
companies when they are
comunidades
found responsible
que
for grave
nosotros
violations of human
acompañamos
rights. The
están
communities that
en
we
un nivel de
accompany are
asimetrías
living
enorme
the
frente
power
a todo el
relationship between our
aparato
communities
jurídico tal y
and the
como hoy
legal
está concebido en nuestro país
structures
incluso en el
is
mundo.
totally unequal,
Les
both in
comentaba
Colombia
que
but
en
also
alguna
internationally.
ocasión
And
pruebas
if we
técnicas
are able
luego
to
lo que
develop
encontramos
the
son
technical
esos
evidence, if
niveles
we
de
are able to
estándares
produce
se
technical
solicitan.
evidence,
Aquí en
then
Colombia,
we
el
come up
aire que
against the question
respiramos
of
tiene un
the
estándar de
standards
calidad
that
muy bajo
companies have
frente al estándar de
to meet,
calidad de
because
aire en
the
Europa.
standards
Y
that are
entonces
established by law in
empiezan
Colombia
a
are much
surgir
lower than they
ese
are
tipo
in
de
Europe.
debates,
So
¿no?
the standards that companies need to
Es
meet
decir, hay unos
are
seres
not
humanos que
at the level that they
podemos
should
respirar
be or
aire
that they are
contaminado,
in Europe.
mientras
So
que en otros
even
lugares
if
hay
legal
políticas
standards
públicas que en
often
efecto sí
mean
han
that
pensado
even
que
if they're
esos
met,
niveles o esos
but that
estándares
they're
tienen
still
que ser
dangerous.
mayores.
They're still producing dangerous levels of
La
contamination
cadena
for the
de
communities.
suministros
The
alrededor del
supply
carbón
chain,
sigue siendo también muy compleja.
the coal
En
supply
este
chain is very
momento, el
complex.
principal
Also,
comprador de
currently,
carbón
the
colombiano
principal
son los
purchaser of
Países
Colombian
Bajos,
coal are the
Turquía,
Netherlands,
Irlanda,
Turkey, Ireland,
y nos
and
preguntábamos
we
quién
ask
le compra el
ourselves,
carbón a
well,
Países
who
Bajos.
buys
Seguramente son
coal
países que han
from the
dicho compremos
Netherlands?
carbón donde
No
sí se
doubt,
cumplan
these
estándares,
are countries
donde
that
sí
have
haya
decided to
respeto a
buy
los
the
derechos
coal,
humanos,
their coal from
pero
companies
ese carbón
that do
finalmente
have
está
strict
llegando de
environmental
países donde no
controls,
se están
so that we can
cumpliendo
show
con
that we are
normas,
fulfilling
donde no
our
se
international
respetan los
norms.
derechos
But
humanos, donde
this
no se
coal
cumplen
comes
sentencias
from countries
judiciales.
where
Y lo peor
the
es que,
international norms are not
como les
met,
decía,
where
donde hay una
legal judgments
sentencia
are not
que garantiza
respected,
derechos,
where
entonces estas
judgments are not
empresas
implemented.
demandan al Estado colombiano
And
y
when
eso
the Colombian
hace
the
que
Colombian
se
government does
consolide un
legislate
efecto
adequately,
los
the companies
académicos
then
y los
go to international
expertos
arbitration
señalan es
and
el
sue the
efecto
company
de
in the international
enfriamiento.
arbitration tribunals.
Enfriamiento en las
And this
políticas
leads to
públicas
this
para poder mejorar
freezes,
esta
it leads
situación,
to what we call
enfriamiento en el sistema
a
judicial
cooling down of the
y prácticamente
intention
nuestros
of the
estados le
government
están
to
teniendo
protect
miedo
environmental
a
protection.
las demandas de las
States are more and
empresas
more
ante el
scared
Tribunal de
of
Arbitramiento
the
Internacional
being
porque no
sued
es un
by companies in the
sistema
international
justo, es
arbitration
un
system,
sistema
because the
hecho
system
para
is not
que las
fair.
empresas
It's a system that has been
protejan sus
developed in
inversiones y no
order
se
for
puedan discutir
companies to
otros
protect their
parámetros, por
interests.
ejemplo, como lo
And it is not
ambiental,
possible
como los
to
derechos
include
humanos
discussion of environmental
en estos
matters,
casos.
of human rights in these tribunals. They're not admitted
Sí, yo
in
dejaría ahí
the
para dar
subject matter of the
lugar
arbitration in the international
a las
tribunals.
preguntas.
So I'll leave it there so that we can have some questions.
Thank you, Rosa Maria. Thanks very much. And all of the presentation, excellent presentation, raised a lot of the themes and tensions that we come across at LIDE in our work quite regularly. I just wanted to add on one further example of a case that we've been working on recently, which I also should say we settled on a confidential basis without the admission of liability, which was also a case relating to extraction of natural resources in Colombia, where we represented a group of Colombians, largely subsistence farmers and their families living in the Amazon near the border to Ecuador, where in very remote and rural communities without access to piped water. And this was a case against the English oil company Amerisur, which was active in the area for many years. Because there was no piped water in the area, our clients used the local water sources for all of or most of their everyday needs, such as bathing, drinking, swimming, but also irrigation, livestock, and so on and so forth. Our client's case related to an oil spill that occurred in the vicinity in that area, which resulted from a terrorist attack on oil tankers, which transported the defendant's oil. And this oil spill was alleged to have polluted a wetland in the area, from there the oil, it was alleged that the oil got to most of the watercourses in our client's area. And one thing that's very interesting, interesting in the context of natural resources and sustainable development is is one point of Colombian law, which, as you've heard earlier, is the law, the domestic law is under international law is what applies in such kind of a transnational case. And this is the concept of liability for damage caused by dangerous activities, which is something that we relied on in this case. And oil exploration and transportation is something that is recognized as a dangerous activity under Colombian law. And this concept provides that if you are the guardian or co-guardian of a dangerous activity and that dangerous activity causes harm, then you're generally liable. So it's a type of strict liability without having to prove fault. That's except for some very narrow exemptions. And of course, this doesn't provide a route against authoritarian regimes. And also it doesn't necessarily mean that communities can access their resources fully and freely in the first place, but it does provide a potential avenue where damage has occurred.